We have discovery that was turned over by the county attorney's office that shows that their own investigator had already repeatedly attempted to get a hold of Detective Saldate, and that he first avoided them on numerous occasions, and then on July 26th, when they finally did catch up with him at home with a subpoena in hand, that he indicated that he did not want to cooperate, that he planned to hire an attorney, and that he was planning on asserting the Fifth Amendment, and that he wouldn't testify without any type of immunity. So certainly, and that was before, certainly well before the time that the judge asked if Mr. Saldate wanted an attorney, and any judge, responsible judge, who would read the Ninth Circuit opinion, which is it is law of the case, would be concerned, to say the least, and it would be her judicial duty to ensure that Mr. Saldate wanted to proceed without an attorney, or that he was able to have an attorney advise him before testifying.
One of the things that bothered me by Mr. Montgomery's comments, too, is this continuous attack that they have been making in this case against the Ninth Circuit. They have done that repeatedly in all of the hearings that we've had. The judge has made it very clear to them that that is the law of the case. What is astounding to me, that you hear lawyers, which Mr. Montgomery is, and even Mr. Mardino, sit here and think that they can dissect the Ninth Circuit and change that ruling. And that's what this is all about. They want to challenge the ruling of the Ninth Circuit. It's law. They have to obey the law. And maybe they don't like it, but that's the law of the case. And the judge has told them that over and over again. Yet they go back and attack it. And I think what they're trying to do is to use all of this to try to get Saldate to change his mind indirectly. And, one of the things they're getting here, in which they haven't talked about, is Mr. Saldate, on his own, found an attorney. We have never talked to Mr. Saldate in any way. He went out and got an attorney who's an excellent attorney, who obviously had confidential conversations with him, and based upon those conversations and what he knew about the case, he advised him he should invoke his privilege against self-incrimination, and that's exactly what he chose to do. And that's what Mr. Debus, his attorney, represented in court when we were there the last time. And yet you have the county attorney's office talking about how they should go over here and have Mr. Saldate look at all of this stuff so they can change his mind. They're actually interfering with the attorney-client relationship. And it's astounding to me to sit there and listen to Bill Montgomery, who is a lawyer, say these things out here in public, that he is going to now attack the Ninth Circuit opinion. It's basic law school 101. You just don't do that. As defense attorneys, we get opinions all the time we don't like, but we live by them. And that's the law. And that's what our responsibility and our duty is as officers of the court. And to attack the judge in this case and try to say in the pleadings that she's intimidating somehow Saldate into not testifying is just outrageous. She did what any responsible judge would do, because you have a Ninth Circuit opinion that says they're going to refer the case to the U.S. Attorney's Office as well as the Justice Department for possible civil rights violations. And, it goes on beyond there. That's not the only place where Mr. Saldate probably has a basis to take the Fifth Amendment. There may be things that we don't even know about that he doesn't want to talk about, be exposed to, as why he's telling his attorney why he needs to take the Fifth Amendment. We also know there's a new incident with another woman that he's been alleged to be involved in, which could involve him wanting to take the Fifth Amendment in this case. So to sit here now and say, well, we don't think there's any reasonable likelihood he's going to be prosecuted, and therefore he doesn't have any right to take the Fifth Amendment, is just preposterous. And yet that's what Mr. Montgomery said repeatedly in that press conference today. And I didn't hear the entire press conference. I only heard a part of it.
They clearly went after the Ninth Circuit and went after you guys and said things like, he's not going to stand by and let you dance on the grave of Christopher Mielke. These are strong words. In many ways, this seems like it's become personal, acrimonious. The bottom line is, what is the bottom line to this? What do you think about when?
Well, the bottom line is I go back to our first emotion where I see the office where we raised the fact the office, which we lost, was that they had a conflict in being involved in this case. It seems to become personal when you see personal attacks like this coming from the chief prosecutor in your county.
But this isn't the first time that Saldate has invoked the Fifth Amendment. He did that just about less than 2 years ago on this eviction case where he was accused of sex extortion again.
I don't know if that's what he did at that time. There were rumors that that's what he purportedly did, but I don't know if that was true.
I've seen the police reports myself. He invoked the Fifth Amendment, he refused to testify, and then he resigned as constable. I mean, that's a matter of record.
He went, half of his news conference was reading a case law, basically saying where the Ninth Circuit got it wrong on everything. Basically, he said, in Mr. Montgomery's contention, Ninth Circuit got all the facts wrong in their criticism of Saldate. You guys are using that to now dance on Christopher's grave. Give me again, what do you say to that?
Well, I'm offended by the fact that when someone says you're dancing on Christopher's grave, that was a horrible crime. It's a horrible thing to say that, when you had such a horrible death. I think of my client, Deborah Melke. I mean, you're sitting here and making aspersions that we're dancing on her son's grave and what she feels. This woman is innocent. She is absolutely torn up by statements like that. And it's an irresponsible statement. We're certainly not dancing on Christopher's grave. And all he's doing is out there trying to make some kind of a public statement about something which is totally irresponsible. It's totally not supported by the law. And it's certainly not fitting in terms of somebody who is supposed to see that justice is done. This is not an office that's trying to see justice being done right now. This is an office that's engaging in vindictive and malicious prosecution. And that was evident today by Mr. Montgomery's statements that he made to the press.
Let me ask you a question about the prosecutor of the year twice in Pima County, a fellow by the name of Ken Peasley. In another death penalty case, he put on a police witness, according to the Supreme Court records that I looked at for disbarment, that he knew was not going to tell the truth. He put that witness on. He was disbarred and prevented from practicing law ever again. How is this different?
Well, I know the Peasley case. There was a lot more to it than that, but yes, there are ethical considerations in here. There are some, and we have talked about that recently, especially in light of the comments that were made today by Mr. Montgomery. I mean, there are some ethical issues here that need to be addressed. For one, even interfering with the relationship between Mr. Saldati and Mr. Debus, which they have a relationship, and it seems like he's interfering with that. I would certainly think that when he looks at the Ninth Circuit opinion, when you have cases in there that are already have findings of law, they're judgments, and then to try to say they're wrong and pick apart the facts. And if you even look at the way he analyzes the facts, he doesn't even do that very well. I mean, his statements are just way off in terms of everything he's doing. And if you're trying to be responsible and trying to follow the law, and you're trying to be objective about the facts, that's not being done in this case. And that's offensive to me.
And one more point, too. I mean, in going through and saying that the court needs to look at all the facts, or all of basically what they were arguments, and the state's position in these various cases that the Ninth Circuit opinion relied on, the state already made those arguments the first time around in the state courts in each of those cases, and they lost those arguments. Those are final decisions that were made. They can't go back and attack those. And then it was only those cases where there's judicial findings that were already made, where those are final determinations that the Ninth Circuit then incorporated and relied on. So to say that the judge can even, or that he could even get into all these other facts is simply inaccurate. The Ninth Circuit opinion itself explains that in using those other cases involving Saldate's misconduct, that the only thing that could be done would be done by us, where we would ask him about the specific case and ask if he engaged in that misconduct. And he would be limited to saying, yes, I did, I don't know, or no, I didn't. And under the Ninth Circuit opinion, if he says, no, I didn't, and he denies that, he has committed perjury. And that is exactly the road that the county attorney wants Mr. Saldate to go down, and that is one of the primary reasons why his criminal defense attorney, who is advising him, is saying, you're not going down that road.
Do you feel like the county attorney made these comments today because he's kind of backed into a corner? Without this testimony, does he have a case?
I don't believe he has a case without this testimony. I think it's pretty clear from everything we've seen. And I think he is desperate, and it's tragic to see somebody get in a corner like this and then start making false statements about the facts of the case, and then attacking a higher court that has studied this case for probably 8 years at least and knows this case intimately, made rulings on this case by a 3-judge panel on the Ninth Circuit, including the Chief Justice. And he's sitting here and saying they're wrong and he's the one that's right. Number one, once that judgment becomes final, he can't legally do that. What is really bothering me is also what Ms. Wolfe was telling you about here just earlier, is because when we were in court on, I think it was August 1st, at that point in time it was represented by the prosecutor that Mr. Saldati was ready to cooperate, and they had been talking with him, and that he was going to be there to testify in this case. And that was said, and when he said that, the judge said, all right then, if I know that, please have him sign, just didn't have to appear, just please have him sign a document that says he understands that he's going to be doing that. It doesn't want to have an attorney or anything. And that's when Mr. Inbordino said he would get that document. And later on, we get this discovery, and we've handed it out to you today. And you'll see in here, this is their own investigator. And Lori just mentioned this to you, that they went to see Saldati on July 26th. Remember, the hearing I'm talking about was August 1st, when he was saying, we've been talking to him. This discovery right here, and I'll give you a copy of it, it shows he was hiding from them. He didn't want to testify. Well, he didn't want to testify. He wanted, when they did meet with him, he was very unhappy with the county attorney's office, very unhappy with the police department, very unhappy with the AG's office. He didn't feel he was being treated properly. He was going to get an attorney, and he was going to seek immunity. And they had that, and they had that knowledge when they made that representation August 1st. And Bill Montgomery had that knowledge today when he says we were tampering with witnesses. And this is before anyone ever talked to Saldati, before he even had his own attorney. This was Saldati saying it to them, and yet they did not disclose that and accuse us of witness tampering, or Mr. Debus of witness tampering, or the court of witness tampering. That is totally irresponsible. And it's sorry to see that the person who's supposed to be responsible for protecting the rights of citizens in this county and seeing justice is done is engaging in that type of conduct.
If Saldati does participate and gives his testimony, are you going to view it as in any way believable?
Well, I would believe it at this point. I mean, think of all the things that the Ninth Circuit has pointed out you can impeach him with. I mean, use your own judgment. You look at a man that has a history of misconduct and lying over and over again in cases that have been overturned by other courts, not just the Ninth Circuit, by state courts here. And would you want to believe this man to the point that you could be found guilty of first-degree murder and end up on death row purely on his testimony? I certainly don't find him believable in what I've seen, and I don't think anyone that really knew the facts of the case, looked at his conduct, look at the man has a history of lying. If you look at that, you wouldn't believe him.
Why would Mr. Montgomery today pass out to the members of the press Broomfield's ruling in the habeas hearing that was overturned? I mean, how is that relevant to us or anybody? Why would he use that?
Well, it's actually, from a legal ethical standpoint, that's probably improper. Yeah, that opinion was overturned by the Ninth Circuit, basically. They looked at that opinion. What he's trying to do, quite frankly, I think, is use the media and confuse the facts and the issues by interjecting some of these earlier things in the case. They're saying the Ninth Circuit's all mixed up, so people will get confused and say, oh gosh, maybe Soldati's really right, and that he's not really a person here that the Ninth Circuit is saying is so bad.
Well, and they had their opportunity.
Yeah.
If they wanted to say the Ninth Circuit opinion was wrong, there was a means by which to do that. It's called a petition for certiorari to the U.S. Supreme Court. The state did not file one, and that's what made the Ninth Circuit decision final. They can't come back after the fact now and say, and argue it was wrong. And that's why the judge keeps telling them, you know, this is law 101, this is law of the case, period. Is that it?
I got it.
Okay, he'll be here all day.
Well, I think.
Okay, we're finished, Kevin.
Here, let me give you this stuff, actually.
Thank you very much.
Thank you.
Yeah.
Appreciate it.
You've got a